Hi everyone. Uh, we have to start with the last case, that is Dalip Kaur versus Jeewan Ram. This case number 32, and we have discussed 29 and 30. I've already told you that 28 and 31 for the time being is not a part of your syllabus. So first we'll discuss 32 case, and the next video will consist of the remaining essential ingredients, and after this I'll start with the fresh topic. Most probably it will be vested in contingent interest, that is topic number 8. Okay, it's on page number 159, the Dalip Kaur versus Jeevan Ram case. Now again, this case is related with essential ingredient number 1, read with the explanation that whether the special leave petition which is filed before the Supreme Court, it will still be considered as a continuation of the proceeding and the doctrine of lis pendens will be applicable or not. So here it says, are the proceedings in a civil appeal before the Supreme Court in pursuance to the grant of the special leave under Article 136 of the Constitution of India not a continuation of the proceedings in the original suit, and is the principle of lis pendens not applicable to such proceedings. So the issue is basically framed in a negative connotation, where it is said that whether this special leave petition, which is mentioned under Article 136 of the Constitution of India, whether it is not considered as a continuation of the proceedings in the original suit, and on this lis pendens is not at all applicable. So this is a short question that arises in this second appeal. Now from paragraph number 3, the facts are starting, so you need to be very careful while reading, and it's better that you draw an illustration while reading the facts. It says, Lachman, respondent number 24, filed a suit for the possession by way of preemption of the land. Now by way of the preemption, so preemption are the preferential rights in a immovable property. So preemption rights are like right to way, right to passage, right to air, etc. So it says Lachman, respondent number 24, filed a suit for the possession by way of the preemption of the lands measuring 9 canals, 9 marlas, which had been sold to the respondents 1 to 5, that is the original vendees. A part of this land had been sold by the respondent 1 to 5 to respondent number 6 to 21. So they are trying to say here that this Lachman, respondent number 24, so the suit is between Lachman, respondent number 24, and respondent number 1 to 5. So Lachman, so you have to write on one hand that Lachman R24, or the plaintiff in our present case, so he has filed a suit for the possession against the respondent number 1 to 5. Further, this respondent number 1 to 5 has sold the property to respondent number 6 to 21. So it says Lachman, respondent number 24, filed a suit for the possession, not on the basis of the title, but on the basis of the possession. They are saying filed a suit for the possession by way of the preemption of the lands measuring 9 canals, 9 marlas, which had been sold to the respondents 1 to 5 original vendees. A part of this land had been sold by the respondents 1 to 5 further to respondents 6 to 21. The suit for the possession by preemption, underline, was decreed by the trial court on 22nd August 1983. So that means Lachman had filed the suit in the lower court, so he was the plaintiff at that time. The trial court has given a decree in his favor. So it says the suit for the possession by preemption was decreed by the trial court on August 22nd, 1983. In pursuant to this decree, underline, in pursuance to this decree, Lachman took the possession of the suit land on October 6, 1983. Further, it says that the appeal filed by the respondents, now obviously plaintiff and defendant was there. The decree was passed in favor of the plaintiff, so the aggrieved party will be the defendant, so he has filed an appeal. So it says the appeal filed by the respondents 1 to 5 was dismissed by the learned district judge on 18th March 1985. The second appeal to this court was dismissed on September 26, 1985. Again, it was dismissed. Underline, thereafter, respondents 1 to 5 filed a special leave petition under Article 136 of the Constitution of India. Leave was granted. So before you file an application before the Supreme Court of India in order to basically in order to file the SLP before the Supreme Court of India, you need to first take the permission. So the permission was granted. So it says that the leave was granted. Underline, the appeal of respondent 1 to 5 was accepted, wide order dated 5th October 1989. Underline, accordingly, now from here you have to pay attention. Accordingly, the suit filed by the Lachman was dismissed. So first appeal, second appeal filed by the respondent number 1 to 5, leave was granted, and in that the suit which was filed by the Lachman was dismissed. Thereafter, underline, thereafter the original vendees. Now please put an arrow and write that as far as original vendees are concerned, they are respondent number 1 to 5. So respondent number 1 till respondent number 5, they were considered as the original vendees. So thereafter the original vendees and respondent 6 to 21. Why? Because respondent number 1 to 5, they have further given the possession to respondent number 6 to 21. So that is why it says that thereafter the original vendees and respondent 6 to 21 filed an application under section 144 of the CPC for the restitution of the possession. So they are trying to say here that once the in the second appellate court, the order was reversed, the trial court order was reversed, so they have separately filed an application under section 144 of the civil procedure, which basically says about the restitution of the possession, so in order to claim back the possession. So who has actually filed this particular application under section 144 of the CPC? They were the original vendees, that is respondent number 1 till 5 and respondent number 6 to 21. Now again you have to pay attention. Paragraph number 4 says the appellants. Now appellants, that means the Lachman in our case, Dalip Kaur. Now the appellants along with the respondents 22 and 23 filed the objections. Now what happened, this Lachman has also further sold the property to the appellants in our present case. So the appellants in our present case is Dalip Kaur. So basically Lachman, who has actually acquired the possession via this decree, he further sold the possession to the appellants. Now later on, respondent had filed first appeal, then second appeal, and in that second appeal the matter was actually passed in their favor, thereby saying that the possession should be reverted back to the respondent number 1 till 5 and respondent number 6 till 21. So please pay attention. The appellants along with respondent 22 and 23 filed the objections alleging that they had purchased, keep on underlining, that they had purchased the suit land from Lachman. So further Lachman has also sold the property. So they had purchased the suit land from Lachman, being bona fide purchases for consideration. So they were not aware of the facts that already there was a matter pending before the court, and there was leave was granted, and in this appeal special leave petition, the order was passed in favor of the respondent itself. So here they're trying to say that being bona fide purchases for consideration, so they have paid the consideration also, the petition under section 144 of the code was not competent. So they are alleging that that respective application which was filed by the respondent number 1 till 5 and 6 till 21, it should not be accepted. So further it says respondent 1 to 21 filed reply to the objection. So objection was raised from the side of the appellants along with respondent number 22 and 23, and the reply to the objections were given from the side of the respondent number 1 to 21. So when I'm saying respondent 1 to 21, so you have to remember 1 to 5 plus 6 to 21. So in total 1 to 21. So it says respondent 1 to 21 filed reply to the objections and pleaded that the matter was governed by the principles of lis pendens. So they have given the reply to that respective objection that as far as the concept of lis pendens is concerned, it is very much applicable on this particular issue. So the learned trial court framed the following issues, please mark. First, whether the objections from the side of the appellants, whether the objections are maintainable as alleged in the objection petition can you see yourself that OPP is written? Put an arrow and write that OPP means onus of proof on the plaintiff. So court has framed the issue and they have mentioned OPP. So OPP means that first it is the plaintiff who has to prove. So whether the objections are maintainable as alleged in the objection petition. Second, relief. Now further it says, by judgment dated February 23rd, 1994, the learned trial court rejected the objections. So please once again pay attention to paragraph number 4. Who has filed the objection? It is the appellant, that is the Dalip Kaur, and respondent number 22 and 23. So go back to paragraph number 5 and read it again. While judgment dated February 23rd, 1994, the learned trial court rejected the objection. They raised the objection, so it was rejected. On appeal, again they were not satisfied. On appeal, the order of the trial court having been affirmed, the objectors have filed the present second appeal. So because they were not satisfied with the decision, so again they have filed the present second appeal. Now let's see the contentions under paragraph number 6. It says that the sole contention raised by Mr. J.R. Mittal, that is the learned counsel for the appellant, is that, underline, that the principle of the lis pendens does not apply to the proceedings in the appeal before their lordships of the Supreme Court. So they're trying to say that when the matter is presented before the Supreme Court under Article 136, even if it is SLP application, over there, that means at that stage, this concept of lis pendens will not at all be applicable. So here further it says, he has placed firm reliance on the decision of this court in Meva Singh versus Jagir Singh. The claim, underline, the claim made on behalf of the appellants has been controverted by the learned counsel for the respondents 1 to 21. So obviously he is saying that lis pendens will not be applicable. So the counter reply is coming from the side of the respondent number 1 to 21, that is 1 to 6 plus 1 to 5 plus 6 to 21. So they are saying that no, doctrine of lis pendens is very much applicable even if the matter is pending before the Supreme Court. So further it says, now please mark paragraph number 7. The entire paragraph is very important. I mean, this is a ratio which you have to write in your exam. So it says, firstly, it deserves notice that the Supreme Court is the head of the pyramid of the judicial system in this country. This you are very much aware. It exercises original and appellate jurisdiction. It has the power to pass such decree or make such order as is necessary for doing complete justice in any cause or matter, and any decree so passed or order so made shall be enforceable throughout the territory of India. This, I guess you are aware of all this. The law declared by the Supreme Court is binding on all the courts within the territory of India. Underline, under Article 136 of the Constitution of India, the Supreme Court has the discretion to grant special leave to appeal from any judgment, decree, determination. Read these words carefully. Judgment, decree, determination. Judgment, decree, determination, till here civil procedure code they are talking about, because this article is under the Constitution of India. Sentence, criminal also they are talking about, or order. It can be a preliminary order also, final also, or order in any cause or matter passed or made by any court or tribunal. So or tribunal, they're trying to say that even if the matter is pending before the tribunal court, again Article 136 is very much applicable. So in any cause or matter passed or made by any court or tribunal in the territory of India. So this is the power which the Supreme Court can exercise. Their lordships can even interfere with an interlocutory order, the interim orders they are talking about. The powers conferred on the court under the Constitution are very wide. This power has been invoked and exercised. Read very carefully. This power has been invoked and exercised not only in case where substantial question of law are involved, but even in those where the High Court has come to a wrong conclusion from the evidence. So substantial question of law, and even if the evidences which were taken before the High Court, even if at that stage there is an error committed, again the Supreme Court does have a power under Article 136 to correct that respective decision taken by the High Court. The court has interfered with the orders passed by the High Court in the second appeals or the revision petitions. In the present case, underline, in the present case, the decree which had been passed by the trial court and affirmed by the lower appellate court as well as this court in second appeal was reversed by their lordships. The decree having been reversed, underline, the decree having been reversed, the parties were clearly entitled to the restitution of the possession. So it was reversed. So obviously they can once again restore their restore the possession of their property. So they are saying that section 144 of CPC will be applicable. So the decree having been reversed, the parties were clearly entitled to the restitution of the possession. Keep on underlining the mere fact that the present appellants, now the present appellants again you have to remember they are the persons to whom Lakshman has sold the property, Dalip Kumar. So it says the mere fact that the present appellants were not a party before the Supreme Court is of no consequence as their interests were duly represented by their vendor who was admittedly a party. At the lower level they are talking about, at the lower level it was a Lakshman who was a party. Still further, there appears to be no warrant for the view that the proceedings are not a continuation of the original suit. The mere fact that the leave to appeal has to be obtained under the Constitution does not mean that the doctrine of lis pendens would not apply or that the decree holder shall not be entitled to the restoration of the possession. Now, in the next paragraph, again there is a reference of Meva Singh case. So please go back to paragraph number 6 where the same case is mentioned, Meva Singh versus Jagir Singh. So you can see yourself that the appellant has relied on this case, Meva Singh versus Jagir Singh. So again the court is reviewing that whether this case is applicable and the facts of this case is applicable in our present case or not. So it says, as for the decision in Meva Singh case, it deserves mention that in this case the dispute was not decided on merits but in terms of the compromise, underline, but in terms of the compromise arrived at between the parties. It was further found that the appellants had recognized the fact that they were not entitled to get back the possession of that land from Purushottam Das Ratan. So the facts of Meva Singh is going, as he was not a party to the appeal and his absence, it could not be held that the gift in his favor was fictitious. For these reasons, the appellant cannot now seek the assistance of the court to get the possession of 30 vigas of the land from Purushottam Das Ratan. So they are telling you the reason that why in that particular case, Meva Singh, lis pendens and restoration was not applicable. Underline, it is no doubt true that his lordship was pleased to observe that 136 of the Constitution is an extraordinary remedy and is not in the ordinary line of appeal. However, it was also observed that there is no doubt that the transferee, underline, however, it was also observed that there is no doubt that the transferee during the pendency of a suit or other proceedings is bound by the result thereof, but that principle cannot be made applicable to the facts of this case in view of the insertion of clause 4 in para 10. So again it is Meva Singh case which is going in continuation of the petition of compromise, and then its deletion, which were conscious acts and amounted to not disturbing the rights of the Purushottam Das Ratan. So this is the entire paragraph is on the facts and the decision of the Meva Singh and how it is not applicable to our present case. Last 3 lines are important mark. It was thus clearly a case on its own facts. However, the principle that the transferee during the pendency of the proceeding is bound by the result was recognized. This is precisely what has happened in the present case. Underline the last paragraph. In view of the above, the question posed at the outset is answered in the negative. It is held that the proceedings before the Supreme Court are a continuation of those in the original suit, and that the principle of lis pendens as well as the restitution shall apply to the proceedings. Accordingly, it is held that there is no merit in this appeal. It is dismissed. So what is the conclusion coming at? Even if the matter is pending before the Supreme Court, even if you have filed SLP or a normal appeal is going or a second appeal is going, till the time all the remedies are not exhausted, it will be deemed that as if the matter is pending, and on that the doctrine of lis pendens will be applicable. So in the next video we will discuss the remaining essential ingredients of section 52. So next video will be the last video for this topic 9, that is section 52. Thank you.